Hi, welcome to Commercial Law Tutorials. Let us discuss in detail the law of contract. So, what are the essentials of a valid contract? The first one is there should be agreement. Then the second one is legality. Next, contractual capacity. Then necessary formalities should be upheld. Next, performance must be possible. And then there should be serious intention to contract. And lastly, agreement must not be vague. The next essential is parties must have full legal capacity to contract. The agreement must be made within the limits of the parties, that is, contractual capacity. While the general rule is that every person is able to contract freely within the limits of the law, the following are persons of limited contractual capacity whose power to enter into binding agreements is subject to specific rules. Minors. A minor is an unmarried person under the age of 18 who is under the custody and lawful authority of a guardian whose duty is to maintain the minor until he can maintain himself, administer property, and assist in contracting. The minors who enter into contracts unassisted. What does the law say? The general rule is that a contract made by a minor without the guardian's assistance is void as far as the minor is concerned and valid as far as the other party is concerned. The option of treating the contract as void or valid rests with the minor, or more precisely, his guardian. If the minor chooses to treat the contract as valid, he can make the other party to perform, and he will then also have to fulfill his own part of the contract. If the minor prefers to treat the contract as void, the other party cannot force the minor to perform his part of the contract. A minor who has already performed can recover from the other party whatever he has paid or delivered, but he may not keep what he has received under the contract. He must also restore what he received. This is seen in the case of Forgit, a minor, without his guardian consent, entered into an agreement with Tenny, the principal of a business college, to attend typing classes for 2 weeks in March and the whole of April. He paid for the March lessons but then stopped attending and refused to pay the April account. It was held that Forgit benefited from the contract only to the extent of the lessons actually received, and those lessons having been paid for, there was no further obligation on him. Those minors who enter into contracts while assisted by their guardians, the general rule is that a minor is bound by contracts made on his behalf by his guardian or made by himself with his guardian's assistance, given at that time, beforehand or afterhand. A minor can enter into a legally binding contract while assisted by the guardian. The guardian's consent may be express or tacit, or may be implied from the fact that the guardian, with full knowledge of the transactions, raised no objection. Thus, the guardian, after knowing what the minor wanted to do, remained quiet. That way, the guardian would have impliedly agreed fully to the contract of the minor. The guardian can also expressly agree to the contract. A guardian need not consent to the contract before it is made. It is sufficient if, knowing the terms, he gives his consent after the event and so ratifies the contract. Contracts benefiting the minor are upheld, as seen in a case where a minor, 8 days before his majority, signed a promissory note on an endowment policy valued $750 in his favor on the authority of his guardian. Skate, the minor, being short of money because of his spendthrift, repudiated liability. It was held that Skate was bound by the contract. Assisted contracts, which are clearly beneficial to a minor at the time they are entered into, are binding on the minor, even though they extend beyond his majority. Then There are also contracts which do not benefit the minor. They can be terminated by the court. As happened in this case, where Wood's father used interest belonging to his minor son to buy a house on an installment basis. It was later established that the house was worth only 1,550. Wood lived on and off in the house as he was in boarding school some of the time. On attaining majority, a substantial amount was still owing. He then sought to cancel the contract. The court ruled that assisted contracts which are substantially unfavorable to a minor, especially those extending beyond minority, may be set aside by the court along with restitution upon application by the minor when he reaches majority. The court noted that in this case, the price was too excessive. Wood did not really require that property. It hampered him in his free administration of his income, and the terms were so harsh. Wood no longer had any freedom. The contract was too long and it had a large sum of money, so the court cancelled it. We have been talking about minors. Now we are moving on to married women subject to marital power of their husbands. A couple who enter into an antenuptial contract in Zimbabwe, for example, that is before marriage, the woman is not subject to husband marital power and will be free to enter into contracts. The contracts will be valid. But however, married women who are under community of property, marriage, agreement, are subject to marital power of their husband and have limited power to contract. The wife's capacity is similar to that of a minor under the guardianship of her husband. She has no power to enter into any contract and bind herself or her husband unless such contract is subsequently ratified by the husband. If she purposes to do so, the contract is void. These do not apply in the cases of necessities. So we are saying that wives who have limited capacity to contract can enter into contracts freely when buying only necessities. For example, in this case, Gammon met his wife on the way out to settle in South Africa and married her soon after arrival. Not long after settling, he grew tired of her. The marriage was short-lived and unsuccessful. He then forced her to leave him and return to Cape Town where she bought necessities. Maclay, the wife's brother, sued Gammon to repay money he spent on maintaining Gammon's wife. It was held that a husband is bound to support his wife who left him owing to his misconduct and is liable to pay for all necessaries supplied to her. Now, mentally ill persons, they also have limited capacity to contract. A contract made by a mentally ill person is void if at the time of the agreement he could not understand and appreciate the transaction into which he entered, or if his consent was motivated or influenced by an insane delusion caused by mental disease. For example, in this case of Lanchi versus Lanchi, at the time of his marriage, Lanchi understood the nature of the contract and appreciated the nature of the obligations he was undertaking, but he was already suffering from mental illness. It was held that the marriage should be declared null and void from the beginning. Next, drunk persons, they also have limited capacity to contract. Intoxication, which is severe or chronic, which makes a party unaware that he is contracting or unable to appreciate the nature of the contract, renders the contract void. Intoxication of a lesser degree will be of importance only if induced by the other party to the contract in order to gain an unfair advantage, in which case restitution will be granted. A drunk person can incur an obligation on the grounds of enrichment though. That is, if a drunk person enters into a contract while drunk where he benefit, he should restore what he benefit while drunk to the other party. This safeguards people from parties who pretend to be drunk so as to defraud others. The next group of persons who have limited capacity are prodigals. A person who is reckless in spending his money, who spends his money foolishly and flitters away his estate, is referred to as a prodigal or a spendthrift. This person is given someone, a curator, who protects his estate and is hence forbidden from contracting without the assistance of a curator appointed by the court. The curator can be the prodigal's relative or other interested person. Any contract entered by the prodigal without the assistance of the curator is void. It was seen in the case where a wife alleged that her husband, to whom she had been previously married but from whom she was now divorced, was squandering his assets and was almost continually under the influence of liquor. It was held that an order should be granted declaring Silly a prodigal, interdicting him from dealing with his property and appointing a curator to his property. Then next we have alien enemies. An alien enemy is a person residing or carrying on business in an enemy territory, and any contract made with him in times of war is void. Next, we have insolvent person. Insolvency is the condition of a person when his financial position reaches the stage that he is unable to pay his debts or his liabilities exceed his assets. In such an event, the condition of the debtor is officially recognized by the law for the protection of his creditors and others, so that he cannot keep on contracting and piling more debts he cannot pay. The person is declared insolvent. The effect of this is that the debtor becomes statutorily insolvent and all his property is placed under the control of a trustee who distributes the proceeds among the various creditors in accordance with the Insolvency Act. The insolvent becomes subject to legal disabilities. He is forbidden from contracting in any way which involves his property, and this continues until his estate has been finally distributed and he has been rehabilitated. Thus, an insolvent may not contract in such a way as to dispose of any property of his insolvent estate. He may not, without the written consent of his trustee, enter into any contract whereby his estate is likely to be adversely affected. We have the artificial persons. An artificial or juristic person is an entity created by law and given certain legal rights and duties of a human. The entities are allowed by the law to have rights and duties separate from the members who form them or direct their affairs. The most common examples are companies, universities, and parastatals. If an artificial person enters into a contract which it has no contractual capacity to make, the contract is void and cannot be ratified. In order to determine the contractual capacity of a corporation, you must look at the statute that created it. Its memorandum of association is the one which determines its contractual capacity. For example, a registered bread making company cannot start to teach students in the bakeries, sell beer or raw meat as well as hair products using that same memorandum it was given for the purpose of baking bread and bread-related products. This is not allowed. This happened in the case where a company which was authorized by its memorandum to carry on business of costumers and gown makers embarked on a business of making veneer panels and erected a factory for this purpose. The company later went into liquidation. 3 creditors, a firm of builders who constructed the factory, a firm who supplied veneer, and a firm who supplied coke, all proved in liquidation. The liquidator rejected their claims. It was held that their claims were rightly rejected on the grounds that the contractors were ultra vires beyond the company's powers. Let us look at illegal associations, which also have limited capacity to contract. An illegal association has no right to appear and be heard by the courts, and any contract made by it is void and unenforceable, although the courts consider ratification in some cases. But under the doctrine of unjust enrichment, a remedy lies against its members who have derived benefits at the expense of others to which they were not entitled, and any person trading with an illegal association or with its members has a liability to pay for benefits he received. Now, the questions relating to this lesson. What is a contract in law? Explain fully how it is formed. Explain the essentials of a valid contract. Critically analyze this view. All minors are bound by all contracts they would have entered into unassisted. Briefly explain the following terms: estupi cosa, in par delicto rule, the paro evidence rule, contra profentram rule. Explain the cardinal rules of illegality in the law of contract as per the case of Jajbhay versus Cassim. Give examples of contracts entered by a minor which are generally void under law, and also the contracts for which, if a minor enters, cannot be considered as void. Discuss the circumstances in which a minor may acquire without his guardian's assistance a perfectly valid obligation in the law of contract. Not all persons possess full contractual capacity under law. List and explain the categories of persons with limited contractual capacity.